439, my lord. But, last Friday, my lord, I was reading the 482 petition at page 64. My lords had considered all the facts of the case, my lord. This is as regards, my lord, issuance, my lord, of a forged bank guarantee for execution, my lord, of the contract, my lord. Lord, and that, my lord, was found to be forged, and there were two bank guarantees, my lord, which were issued. If your lordship may just have page 64, my lord.
64, yes.
Lord, these were, my lord, the contentions which were raised, and your lordship, my lord, had considered all that. It's page 64, my lord. If your lordship will permit, may I read, my lord?
Please.
Learned Senior Counsel appearing for the applicant submits that applicant had entered into a contract with Airport Authority of India for carrying out certain work and had furnished bank guarantee for a sum of 27,10,400 for undertaking the work of vehicle parking at Raja Bhoj Airport, Gandhinagar, Bhopal. The aforesaid bank guarantee was obtained from Bank of India, Mira Road, Thane, Mumbai. But in the first information report, it is mentioned that the applicant forged the bank guarantee of 27,10,400, whereas fact of the matter is that the bank guarantee number such and such was admittedly obtained on 22/7/2016 and it was closed on 3/8/2016. Thus, the contention of the complainant that the applicant forged the bank guarantee is not made out, as it apparent from the clarification issued by the bank on 24/8/18 contained in Annexure A8 annexed with MCRC such and such. But there was an anticipatory fine, which was subsequently dismissed. It is also submitted by learned senior counsel for the applicant that money was deducted from the account of the applicant, and all these facts were brought to the notice of the Airport Authority of India by letter dated 30th August 18, informing the Airport Authority of India that the original bank guarantee was furnished to the Airport Authority of India, then how the bank guarantee was returned to the bank, and why the bank did not confirm from the Airport Authority of India, which reveals conspiracy and plot to defame and damage the applicant's firm. It is further mentioned in the aforesaid communication that decision of the authority be reviewed and coercive action be stopped that was damaging the reputation and business of the firm. It is further submitted by learned senior counsel for the applicant that tender was invited on 21st November 15 for period from 12 April 16 to 11th April 19. The work order was issued in favor of the applicant and the bank had informed that the aforesaid bank guarantee was not issued. Thereafter, the bank clarified that the bank guarantee was issued on 22nd July 16 but was encashed on 3rd August 16 upon specific request letter signed and furnished by the applicant himself. On 7th September 18, the bank guarantee was replaced by a fresh fixed deposit of 27,10,400, and on 1st July 19, after successful execution of the contract, no dues certificate was issued by the authority. However, the amount of fixed deposit was sought to be adjusted toward the dues under a different contract when in WP numbers 17073 of 19, the High Court directed refund of fixed deposit back to the applicant. There was no element of cheating as the bank guarantee was closed 4 months after the contract. Referring, my lord, then, my lord, Sheila Sebastian, SV Palitkar, my lord, all these judgments, my lord, were cited. Hridaynath Ranjan Prasad Verma was cited, my lord. My lord, page 67, my lord, are the observations of the Honorable.
Yes, sir. I've read it.
My lord. Now, my lord, my submission is twofold, my lord. One is, my lord, may kindly appreciate, my lord, investigation is done, my lord, charge sheet has been filed. The final report, my lord, if your lordship may kindly see, at page 84. And the operative part starts, my lord. Page 83 is the final report, my lord. And page 84, 85, my lord, sample signatures of the present applicant were taken, my lord. And, my lord, eventually 173.8, my lord, further investigation only in context of Abhijit Rai, my lord, who was, my lord, the then bank manager, my lord, or Mira Road branch.
Has been,
Lord, he has not been apprehended.
तो आने दीजिए ना
Lord,
दोनों.
if I may just point out why, my lord, it is the case, my lord, no further custodial interrogation. If your lordship may kindly have, my lord, the QD report has been filed, my lord.
अरे ये अभिजीत राय साहब से जब आपका आमने सामने जो है.
सर मैं वही बता रहा हूँ, अभिजीत राय से तो मेरा कोई वो नहीं था, मैंने भी एक FIR फाइल करी. And I'm just pointing that out. Your lordship may just have IA number 19448 of 2023.
Yes, बताइए.
Lord, we had filed this complaint at Thane, and if your lordship may just have page 7.
Yes,
Lord, just to point out, my lord, what were the bona fides. We faced this problem, my lord, at 4 contracts. And all this was done, my lord, by, my lord, 2 people, my lord. One of the managers, Rajesh Kumar Nagar and Abhijit Rai. For, if your lordship may just have page 7, my lord. I'm skipping, my lord, the first 7 lines, my lord. I'm reading this my lord, हमारी एसएस एंटरप्राइज कंपनी भारत सरकार, महाराष्ट्र सरकार, विभिन्न नगर निगमों द्वारा जारी वाहन पार्किंग टेंडर लेने और संचालित करने के व्यवसाय करती है। वर्ष 2017 में एसएस एंटरप्राइजेस कंपनी ने हमारे कार्यालय से ऑनलाइन टेंडर के माध्यम से भारतीय हवाई अड्डा प्राधिकरण सरदार वल्लभ पटेल गुजरात में वाहन पार्किंग का ठेका लेने की प्रक्रिया शुरू करी। पार्किंग टेंडर पास होने से पहले संबंधित कंपनी को बैंक गारंटी पुष्टिकरण पत्र देना आवश्यक है, इसलिए हमने राजेश कुमार नागर को हमारी कंपनी में अकाउंटेंट के रूप में कार्य थे, उसी पर भरोसा किया और बैंक में लगने वाले सभी आवश्यक दस्तावेज बैंक ऑफ इंडिया शाखा शांति पार्क मीरा रोड पर जमा करने के लिए दिए। इसके बाद राजेश नागर ने बैंक ऑफ इंडिया सेंट्रल प्लाजा बिल्डिंग ग्राउंड फ्लोर मीरा रोड ईस्ट बैंक का मोनोग्राम टू सीनियर प्रबंधक एयरपोर्ट अथॉरिटी ऑफ इंडिया एसपीबीआई एयरपोर्ट अहमदाबाद के नाम पर गारंटी संख्या दिस इज 8,39,000 21 नवंबर 2000 तथा वैध दिनांक 3 से 17 को बैंक पुष्टिकरण पत्र उपरोक्त व्यापार के लिए मैनेजर अभिजीत राय से लिया, ऐसा बोलकर उसने एयरपोर्ट ऑफ इंडिया गुजरात में दिया। इसके बाद संबंधित एयरपोर्ट विभाग ने व्हीकल पार्किंग 23 दिनांक 17/5/17 को हमारी कंपनी को वाहन पार्किंग का ठेका देने के बाद 31/5/17 से एसएस एंटरप्राइजेस कंपनी ने उपरोक्त जगह पे व्यवसाय प्रारंभ किया। हमारे एसएस एंटरप्राइजेस कंपनी में अकाउंटेंट के पद पर कार्य राजेश नागर निवासी सचिन सच इज रेजिडेंट ऑफ मुंबई कई वर्षों से सेवा है हमें, इसलिए हमने उस पर भरोसा किया। हमने अपनी कंपनी के बैंक खाते से प्रतिमाह वेतन उसके सिंडिकेट बैंक मलाड पूर्व खाता नंबर सचिन स्थानांतरित करते रहे। हमारी कंपनी के सिंडिकेट बैंक शाखा मलाड पूर्व एक्सिस बैंक शाखा मीरा रोड द डिटेल्स उपरोक्त कंपनी के बैंक खाते हैं। हमारे एसएस एंटरप्राइजेस कंपनी ने सरदार वल्लभ भाई विमानतल अहमदाबाद गुजरात में वाहन पार्किंग का काम चालू किया, तभी पता चला कि बैंक गारंटी कंफर्मेशन लेटर बैंक ने खारिज किया और हमारी कंपनी जो करार किया था उसके नियम का उल्लंघन किया, ऐसे कारण बता करके पार्किंग का ठेका रद्द किया। इसके बाद तुरंत सीए प्रवीण सिंह से माध्यम से हमारी एसएस एंटरप्राइजेस कंपनी का पूरा ऑडिट किया, तो हमारी कंपनी का एक्सिस बैंक मीरा रोड खाता नंबर सचिन सच 13/4/17 से 4/1/18 तक कुल मिलाकर 73,28,650 ओरियन सोलर सॉल्यूशंस प्राइवेट लिमिटेड के खाते में जमा किए। ऐसे निर्देश हुआ कि बारे में राजेश नागर ने मुझे मालूम नहीं बोला। इसके बाद सीए प्रवीण सिंह के माध्यम से ओरियन सोलर सॉल्यूशंस प्राइवेट लिमिटेड
इंटरनल डिस्प्यूट है भाई, बात की घटना है। अभी यहाँ जो फोर्ज बैंक गारंटी है वो 2016 की है।
मतलब आगे मैं वही बता रहा था, आगे लिखा हुआ है वो पर्टिकुलर वो पूरे एरिया उसके बारे में ये जितना भी बता रहे हैं, मतलब मैं काइंडली अप्रिशिएट ये
बैंक मैनेजर फर्जी बैंक गारंटी बिगर किसी प्रोवोकेशन के क्यों तैयार करेगा?
Lord, my submission is this FIR is what we are saying is
ये ना उनको
Lord,
ये
our submission is Rajesh Kumar Nagar and these people. Now, if your lordship may just have my lord my implication, my lord, if your lordship may just have page 91. This is
yes.
Lord, this is the report. If your lordship would have page 92, विवादित दस्तावेज.
हाँ पढ़िएगा.
Lord, it says आरोपी, my lord, this is the query and my lord the observation, my lord, which has been made, जो अभिमत मांगा है, my lord, that is at the next page. आरोपी संतोष भोलेनाथ शुक्ला द्वारा भारतीय विमान पतन प्राधिकरण राजा भोज हवाई अड्डा भोपाल की वाहन पार्किंग हेतु जारी टेंडर पर लाइसेंस एग्रीमेंट स्टैंप पर जिसके महाराष्ट्र में छपा है, कोषागार न्यायालय थाने 29 मार्च 16 का स्टैंप लगा है। लाइसेंस व्हीकल पार्किंग राइट्स राजा भोज एयरपोर्ट एग्रीमेंट 8 अप्रैल 16 जिसमें संतोष एंटरप्राइजेस प्रोप्राइटर की सील और ये लगा हुआ है। मतलब दिस इज Q1 to Q15। सेकंड इज मतलब आरोपी संतोष भोलेनाथ शुक्ला के नाम पर बैंक ऑफ इंडिया मीरा रोड की बैंक गारंटी नंबर सचिन सच, मतलब इसका वो वाला है कि उसमें जो सिग्नेचर क्लोज एनक्लोज किया हुआ है उसके मतलब उन्होंने बताया दैट इज Q16 to Q28 एंड मलॉर्ड में काइंडली सी ये क्वेरी करी विवादित दस्तावेज एंड देन मलॉर्ड में कम टू पेज 93। कृपया निम्न बिंदुओं पर जांच कर अभिमत देने का कष्ट करें। क्या आरोपी संतोष भोलेनाथ शुक्ला के विवादित दस्तावेज प्रदर्श मार्क Q1 से Q15 तक, प्रदर्श मार्क Q16 से 28 तक, जिन्हें जांच हेतु दिनांक 27/1/23 को जमा किया, स्वाभाविक हस्ताक्षर प्रदर्श मार्क N1 से N12 तक, जिन्हें जांच हेतु दिनांक 27/1/23 को जमा किया है, हस्ताक्षर नमूना तक के हस्ताक्षर एक ही व्यक्ति अथवा मिलान हो रहा है। क्या आरोपी संतोष भोलेनाथ शुक्ला ने विवादित दस्तावेज सचिन सच, मतलब दीज आर जो सैंपल्स थे, नमूना सील स्वाभाविक हुआ है, जिन्हें जांच हेतु दिया गया है संतोष एंटरप्राइजेस
होगा
जी,
जब तक बैंक से वो दस्तावेज जब्त नहीं हो जाते जिनके ऊपर से बैंक गारंटी तथाकथित रूप से जारी की गई थी।
वो सब चार्जशीट में आ गया।
कहाँ पढ़िएगा ना, थोड़ा सा बताइएगा कि बैंक से वो सब दस्तावेज जब्त हो गए जिसके आधार पर 29 मार्च 2016 को सो कॉल्ड बैंक गारंटी जारी की गई थी, उतना बता दीजिए। इसीलिए आपको बोला था कि अभी अधिकारी को आ जाने दीजिए, बैंक वाले को आइए, उसको भी आप
अरे मेरा तो अभिजीत रॉय मलॉट, ही इज इन मुंबई, आई एम अ पर्सन मलॉट,
यू आर आल्सो इन मुंबई।
नहीं
अरे आप दोनों ही तो फिल्म वर्ल्ड के हैं। पता देखिए ना कहाँ लिखा है उसमें, मीरा रोड मुंबई,
नहीं सर, ये वाला
अपार्टमेंट, सेल्फ एम्प्लॉयड।
हाँ मतलब मैं काइंडली
फर्म
अप्रिशिएट।
का नाम भी गोल कर दिया, सेल्फ एम्प्लॉयड हो गए अब।
नहीं अब फर्म मैंने आप उसके
अरे
खुद
भाई,
के
अभी आप तो फॉर्म में,
प्रोपराइटर है
अरे
सर।
प्रोप्राइटर हैं तो आपको लगा कि फॉर्म का नाम जो है मेलाइन हो जाएगा, तो आपने उसको सेल्फ एम्प्लॉयड कर दिया।
नहीं, वो नीचे जो लिखा है वो
अरे
इतना
भाई,
नहीं। नाउ
तो
इफ यू
ये टाइटल ही पढ़ रहे हैं,
जी
उसको आ जाने
मतलब
दीजिए
एक
अभी।
पेज 113 पे इफ यू लॉर्डशिप
हाँ,
काइंडली
पेज
सी
113
जो
देखिए।
उसका ओपिनियन आया मतलब व्हाट माय सबमिशन इज, अभिजीत रॉय के सिग्नेचर्स और वो सारी चीजें देख ली गई। मतलब मैं काइंडली सी अभिजीत रॉय के भी सिग्नेचर्स वो जो थे
ठीक है,
उससे उसको किया एट पेज 113 इफ यू लॉर्डशिप वुड सी
पढ़िए
दैट।
ना, पढ़िए।
मतलब the person who wrote the red enclosed standard signature stamped and marked as N1 to N12 said to be Santosh Bholenath Shukla also wrote the red enclosed question signature similarly stamped and marked as Q16 to Q27. The person who wrote the red enclosed standard signature stamped and marked S1 to S4 and N13 to N53 said to be of Abhijit Roy also wrote the red enclosed question signature similarly stamped. The person who wrote the red enclosed standard signature stamped and marked N1 to N12 said to be of Santosh Bholenath Shukla did not write the red enclosed question signatures similarly stamped and marked Q1 to Q15 and Q28. The red enclosed question seal impression stamped and marked Q35 to Q43 are examined and compared inter se through superimposition test. It is found that there are two sets of questions. Question seal impression. First seal of seal impression is Q35, 36 and second set of seal impression is Q38 to Q43. When both the question and seal impression stamped and marked Q35 to 36, Q38 to 43 are examined and compared with the red enclosed standard seal impression stamped and marked Q S5 to S8, my opinion is that the red enclosed question seal impression stamped and marked Q35 and Q36 do not agree upon content, letter, size, design, and upon superimposition with the supplied standard stamped and marked S5 to S8 clearly establishes the fact that both the sets of seal impressions have
They
not
are
been
different. They are different.
different.
They are
My lord,
different.
as far as signatures are concerned, that your lordship would see, my lord, as far as Santosh Bholenath Shukla is concerned, my lord, that your lordship would find, my lord, at page 117, reference to opinion para number 3.
जी,
My lord, there also the ultimate analysis is, my lord, that in my opinion, there is different authorship between the two sets. Lord, my two submissions, my lord, may I just humbly make, my lord. As far as the allegation of forgery is concerned, my lord, in light of Sheila Sebastian, my lords have already heard it, my lord, and para 20 and 25.
जी,
My lord, my first submission is, my lord, that he cannot be charged for offense of forgery. Now, my lord, as far as the cheating part is concerned, my lord, the no due certificate were already issued in 2019. The entire work was already done. Charge sheet, my lord, is already filed. Now, my lord, my submission is as far as Abhijit Roy is concerned, my lord, his, my lord, seal, sample signatures, everything, my lord, they had already taken from the original records of the bank. So therefore, my submission is, my lord, that he is, my lord, a reputed contractor, my lord, has worked for years together. This is something, my lord, where he has been entrapped and he has, my lord, may kindly see the
Mr.
notice.
Kochar, you understand that reputation is a very fragile thing.
Lord,
It
it is
takes seconds to evaporate.
absolutely, my lord. So, my lord,
And
all I'm,
who is in a better position than you to understand this?
my lord, absolutely, absolutely. Now, if your lordship may kindly come, my lord, to IA number 19448 of 23, my lord.
19? Ah, yes, yes.
19448 of 23.
जी,
Your lordship may come to page 3 onwards, my lord.
जी,
And this is where, my lord, the no due certificate, my lord, which have been issued.
जी,
Now, it also says, my lord, and this is what, my lord, was page 3 and 4.
yes, yes, पढ़ी थी।
Lord, this says, उपरोक्त विषय पर अवार्ड क्रमांक के द्वारा आपको भोपाल विमानतल पर व्हीकल पार्किंग राइट्स का करार प्रदान किया। इस करार में आप द्वारा एफडीआर सचिन सच जमा की जिसकी वैधता दिनांक 5/7/19 तक। चूंकि राजा भोज विमानतल पर आपका कोई भी बकाया लंबित नहीं है, लेकिन वाइजैक हवाई अड्डे पर आपकी फर्म द्वारा संचालित कार पार्किंग करार में इतना बकाया, इसलिए एफडीआर राशि से इसे समायोजित करने बाबत कार्रवाई की जा रही है, क्योंकि नियमावली मतलब दिस वाज द ऑर्डर व्हिच वाज मतलब सब्सिक्वेंटली कॉस्ट मतलब हाउएवर दिस मतलब इज प्रूफ ऑफ द फैक्ट दैट मतलब देयर वाज नो आउटस्टैंडिंग which remained
We
as
are
far
not
as
concerned with the outstanding. We are not the recovery officer for the
all I'm trying
Airport
to
Authority of
Lord,
India.
all I'm trying to say is, my lord, that as far as 420 is concerned as well, there is, my lord, nothing as regards, my lord, any wrongful loss which has been caused, my lord, to the airport authority as on date. So my submission is, my lord, now custodial interrogation is over, charge sheet has been filed, and therefore, my lord, in light of Sanjay Chandra, my lords are already aware, paragraph 20 onwards, my lord.
संजय चंद्रा भी दे दीजिए। पैरा 20।
Para 20 onwards, my lord. Just
जी,
Lord, the appellants are facing trial in respect of offence under section 420, 468, 471 and 109 and section 13.2 and 13.1D of the Prevention of Corruption Act. Bail has been refused first by the Session Judge CBI New Delhi and subsequently by the High Court. Both the courts have listed the factors which they think are relevant for refusing the bail applications filed by the applicant as seriousness of the charge, the nature of evidence in support of the charge, the likely sentence to be imposed upon conviction, the possibility of interference with the witnesses, the objection of the prosecution authorities, and the possibility of absconding from justice. In bail applications, generally it has been laid from the earliest time that object of bail is to secure the appearance of the accused person at his trial by reasonable amount of bail. The object of bail is neither punitive nor preventive. Deprivation of liberty must be considered a punishment unless it is required to ensure that an accused person will stand his trial when called upon. The courts owe more than verbal respect to the principle that punishment begins after conviction and that every man is deemed to be innocent until duly tried and duly found guilty. From the earliest times, it was appreciated that detention in custody pending completion of trial could be a cause of great hardship. From time to time, necessity demands that some unconvicted person should be held in custody pending trial to secure their attendance at trial. But in such cases, necessity is the operative test. In this country, it would be quite contrary to the concept of personal liberty enshrined in the Constitution that any person should be punished in respect of any matter upon which he has not been convicted, that in any circumstances he should be deprived of his liberty upon only the belief that he will tamper with the witnesses if left at liberty, save in the most extraordinary circumstances. Apart from the question of prevention being the object of refusal of bail, one must not lose sight of the fact that an imprisonment before conviction has a substantial punitive content, and it would be improper for any court to refuse bail as a mark of disapproval of former conduct, whether the accused has been convicted for it or not, or to refuse bail to an unconvicted person for purpose of giving him a taste of imprisonment as a lesson. In the instant case, we have already noticed that the pointing fingers of accusation against the appellant is the seriousness of the charge. The offence alleged are economic offences which have resulted in loss to the state exchequer. Though that contend that there is a possibility of appellant tampering with witness, they have not placed any material in the support of the allegation. In our view, seriousness of the charge is no doubt one of the relevant considerations while considering the bail application, but that is not the only test or the factor. The other factor that also required to be taken note of is the punishment that could be imposed after trial and conviction, both under the Penal Code and the Prevention of Corruption Act. Otherwise, if the former is the only test, we would not be balancing the constitutional right, but rather recalibrating the scales of justice. The provisions of CRPC confer discretionary jurisdiction on the criminal courts to grant bail to the accused pending trial on appeal against conviction. Since the jurisdiction is discretionary, it has to be exercised with great care and caution by balancing the valuable right of liberty of an individual and the interest of the society in general. In our view, the reasoning adopted by the learned district judge, which is affirmed by the High Court in our opinion, is denial of the whole basis of our system of law and normal rule of bail system. It transcends respect for the requirement that a man should be considered innocent unless he is found guilty. If such power is recognized, then it may lead chaotic situation and would jeopardize the personal liberty of an individual. Lord, here, if your lordship may kindly see, the entire documentary evidence, my lord, is collected. Most importantly, my lord, may kindly see the charge sheet when it is filed, it is not kept open under 173(8) for the present applicant. It is only kept open, my lord, for Abhijit Roy, my lord. I'm just, my lord, just referring, my lord, to Sheila Sebastian, just two paragraphs.
Yes, yes, please.
Para 20, if your lordship may kindly have.
Para 20 years.
The key to unfold the present dispute lies in understanding explanation 2 as given in section 464. As Colin J. puts it precisely in Dickens versus Gill, a case dealing with possession and making of fictitious stamp, wherein he stated that to make in itself involves conscious act on the part of the maker. Therefore, an offense of forgery cannot lie against a person who has not created or signed it. Lord, after the QD report, my humble submission is, Lord, that I would not be charged with this section. Then, your lordship may kindly see paragraph 21 onwards. Lord, till 24, Lord, Ibrahim Khan, Lord, has been, Muhammad Ibrahim, Lord, has been quoted, Lord. Muhammad Ibrahim also, Lord, paragraph 14 to 17, Lord. I'm not reading that, Lord, because Sheila Sebastian, Lord, takes care of that. Para 25, Lord. Keeping in view the strict interpretation of penal statutes, that is referring
Are
to
they
the...
conducting a trial?
No, Lord, all I'm saying is not just a prime.
आपने कहा 467 नहीं बनेगा.
Lord,
ठीक है
after
ना?
the QD report, Lord.
ठीक.
मैं बस इतना कह रहा
मुझे-
हूँ, Lord, just to prima facie satisfy.
मुझे 5 मिनट के लिए डाउट ये हुआ कि हम ट्रायल तो कंडक्ट नहीं कर रहे.
नहीं सर, मेरा इतना कहना है, I would not take that liberty with your lordship, Lord, for sure.
जी, जी,
Lord, all I'm trying to say is, one prima facie after the handwriting expert report, my lord, And it is not the case, my lord, that it is the document, my lord, which bears my signatures or any of the impressions, my lord. Prima facie, my submission is, my lord, Sheila Sebastian applies. Second submission is, my lord, 420 would not be made out. And now, my lord, in light of, my lord, Sanjay Chandra, my submission is after the custodial interrogation is over, charge sheet has been filed, my lord. In a case of documentary evidence, my lord, I'll just take your lordship's, my lord, attention to all those cases, my lord, in Vyapam also, my lord, where after charge sheet bail was granted, saying that, my lord, now in light of Sanjay Chandra only, my lord, everyone was granted bail, that now the trial would take time, and documentary evidence is that there is no question of any witness being tampered in this case. That's my submission.
Right. या 1995 एससी उठा के लाइएगा, 94 और 95 दोनों डालाइएगा.
I would like to point out two
आप
things.
प्लीज बताइए.
Your Lordship, the FIR has been registered on 1/9/2018.
1/9/2018.
Near about more than 4.5 years, the present applicant was absconded.
हाँ.
He was not cooperated with the investigation, Your
जी.
Lordship. He, after registration of FIR 1/9/2018, he surrendered on 10/7/2023.
जी. जी.
And so the investigation is still going on, Your Lordship, under section 173(8).
जी.
So अभिजीत राय और इनको आमने सामने बैठा के कुछ इंट्रोडक्शन वगैरह
वो तो हमने कहा था, आपने हमारी बात हमें को बता दी
जी,
वापस.
नहीं वही मैं एज योर लॉर्डशिप ऑब्जर्व.
अगर आप इतने सजग हैं तो
जी.
आपने सिर्फ इन्वेस्टिगेशन अभिजीत राय के लिए क्यों ओपन रखा? इतनी मेहरबानी क्यों करी आपने? 10/7 को नाउ यू आर
एक्चुअली
नहीं, एक सेकंड, 10/7 को अरेस्ट हुआ, 11/7 को चार्जशीट पेश कर दी आपने. इन्वेस्टिगेशन, इतनी मेहरबानी क्यों कर रहे हैं आप?
नहीं
बताइए, इसका उत्तर तो
इसमें जो चार्जशीट पेश हुई है,
10/7 को ये अरेस्ट हुए. 10/7 के बाद आपने क्या पूछताछ की कि 11/7 को चार्जशीट पेश हो गई?
सर इसमें 299 में चालान पेश हुआ
वो
है.
तो पहले हुआ था.
1/9/2018.
299 में चालान पेश होने के बाद में इज इट नॉट ओपन टू द आईओ to investigate the matter once the accused is arrested?
Your Lord.
Is it open or not?
Open.
Then why your IO has been so kind to him?
Your Lordship, that Purak Chalan I am not having in diary.
So, who's at fault?
But as per ये चालान has been
अरे
filed
इन्होंने ही तो पढ़ा अभी.
जी, चालान जो फाइल हुआ 299 में फाइल हुआ
11 तारीख को जो ये 11 तारीख की रिपोर्ट पढ़ी ना इन्होंने, अभी बताते हैं आपको पढ़ के.
18/1/2023 को चालान पेश हुआ 299 में.
एक सेकंड, आपने क्या पढ़ा था ना अभिजीत को छोड़ के 173(8) में?
मतलब पेज 70, मतलब पेज 85 में.
पेज 85, जस्ट अ मिनट. 85 की डेट क्या है? डिस्पैच्ड ऑन 11/7/2023. थोड़ा सा समझा तो दीजिए हमको भी. ये 9/7 होता तो हम समझ जाते
जी.
11/7 को आप इतनी मेहरबानी क्यों दिखा रहे हैं?
नहीं, हुआ ये है कि 18
हुआ ये है कि आईओ जो है मिल गया है.
जी.
दिखाइए कहाँ.
सर वो पूरक चालान की कॉपी नहीं है हमारे पास डायरी में.
कौन जिम्मेदार है उसके लिए? Who is responsible for that?
आपने किया.
You are free to intermingle.
Your Lordship.
Anything else? 94 दीजिएगा, ये 94/5 दीजिएगा. ठीक, लिखिएगा. This bail application under section 439 CRPC is filed by the accused Santosh Bholanath Shukla, son of Shri Bholanath Rajpati Shukla. Full stop. This is first application under section 439 CRPC. Case crime number 273 of 2018 is registered at Police Station Gandhinagar, District Bhopal for offence under section 420, 467, 468, 471, read with 120B IPC. Applicant was arrested on 10/7/2023. Full stop. At earlier point of time, his application under section 482 CRPC was dismissed by this court by order dated 21st February 2022 in MCRC number 8135 of 22. Next paragraph. Learned counsel for the petitioner submits that after arrest of the petitioner, final report has been filed by the investigating officer on 11/7/2023, in which it is mentioned that after getting sufficient evidence against the accused Santosh Bholanath Shukla, keeping the investigation open against remaining accused Abhijit Rai under section 173 within bracket 8 CRPC, supplementary charge sheet 05A of 2023 has been prepared and is being forwarded to enclose along with RT number 1142 of 2023 dated 2/2/23. Full stop. Next paragraph. It is submitted that applicant is in fact innocent. He has been duped. Full stop. Reading from the FIR filed along with IA number 19448/2023, which was lodged by the present applicant against certain bank officials, registering case crime number 0026 of 2021 dated 27/1/2020 नहीं 20 है
2020 है.
26/20 recorded on 27/1/2020 at police station Thane Naya Nagar police station, it is submitted that in fact it is the petitioner who had made complaint against one Rajesh Ramesh Kumar Nagar and Abhijit Rai, who were working in ये राजेश भी बैंक ऑफ इंडिया में काम करता है.
नहीं, ये इनका एम्प्लॉय था सर.
किनका?
SS Enterprises का.
Who are respectively employees of the petitioner and of the Bank of India branch Mira Road for defrauding the petitioner by issuing false bank guarantees, as details of which have been mentioned in the FIR. Full stop. It is submitted that in fact petitioner is a victim of circumstances, he is innocent and a man of great repute. Therefore, since investigation is complete, no further custodial investigation is required. Benefit of bail be extended in favor of the applicant. Next paragraph. Reading from the documents filed along with the application for grant of bail, it is pointed out that petitioner has enclosed copy of report dated 12/4/2023 issued by the state examiner of questioned documents. Full stop. Reading from this report, it is submitted that signatures of the petitioner have already been examined by the QID. Full stop. Reading from this report, it is pointed out that though some ambiguity was found in the use of the seal which was affixed on the bank guarantee, as is mentioned that within inverted commas, the red enclosed cushioned seal impressions stamped and marked Q35 and Q36 do not agree upon content, comma, letter size, comma, design, and upon superimposition with the supplied standards stamped and marked S5 to S8 clearly established the fact that both the sets of seal impressions have not been produced from one and the same seal, comma. It is submitted that this finding is in regard to the officials of the bank and not against the present applicant, as he is not the author of the so-called forged bank guarantee. Full stop. Thus, it is submitted that no offense under section 464 IPC is made out. Full stop. Reliance is placed on the judgment of Supreme Court in Sheila Sebastian versus R. Jawahar Raj and another 2018 का 7 SCC 581, wherein reading from para 20, it is pointed out that Supreme Court has held that within inverted commas 20 dot the key to unfold the present dispute lies in understanding explanation to as given in section 464 IPC, full stop, as Colin J. Dot puts it precisely in Dickens versus Gill, comma 1896 bracket में bracket close 2 QB 310 within bracket DC. बैठ जाइए, टाइम लगेगा अभी. A case dealing with the possession and making of fictitious stamp wherein he stated that within inverted commas to make inverted commas close, comma, in itself involves